Hey everyone, welcome back to the channel. Today, we're going to take a deep dive into the story of a sovereign citizen I've been following closely over the past few months. With his jury trial right around the corner, it's the perfect moment to fill you in on everything you need to know. Let's jump right in.
And now we are down to People of the State of Michigan versus David Thompson, file 24-3559FH.
Yep. David and Houghton, appearing on behalf of the AG's office.
Mr. Thompson is representing himself, and I'm advisory counsel in this matter, but I can advise the court there is no other agreement.
All right, so Mr. Thompson is now here, making his way to the defense table.
Yes. Oh, sorry.
Just call me David, you're on.
All right, well, all right, so we are currently set, so you can have a seat. Just as you may have heard me say earlier, don't take any thought. I have nothing to know about the case. I'm just going to tell you that, as I do to anyone here for a final pre-trial conference. Today is the last date in which to enter a plea pursuant to any pre-trial agreement. Any plea from here on out must be done by entering a plea as charged. The reason I do that isn't to punish the defendant, isn't to punish anybody or encourage a case to go in any one direction. It's just to encourage you all to exhaust any negotiating that you've got to do, because everybody's got to issue subpoenas. Subpoenas have to be served by police officers or process servers. My staff has to issue jury notices. 60 different jurors have to reschedule dates and times and take off work, and employers have to do the same thing. So again, there's no punishment. It's just to make sure that we have exhausted all of our negotiating skills. So we have no resolution. The case is currently set for a trial right now. I know we have two trials set for February 18th. Excuse me, this one is set for 1 day. The other one was set for 2 days.
And I was going to, on behalf of the AG's office, I think that they're planning on it, ask that perhaps we keep both of those on. The idea being that we'll be able to conduct both of those trials in that 2-day time frame.
And was there a jury demand, I assume?
Here's the situation. A jury demand has been filed, which means we could miss the last few hearings. There are 4 in total. 2 of these are related to failure to pay child support, and the other 2 involve felony possession of a controlled substance. Honestly, the drug charges are likely at the root of why he's struggling to pay child support in the first place.
I'm going to move this to start on February 19th. So that way we have the 1 day to do the other file and the 2nd day to do this case. So I'll issue jury letters to 4 sets, 4 panels, 2 for each day. So Mr. Thompson, that means that even though your notices say that our trial was to begin on the 18th, we're going to begin it on the 19th. We do jury selection in the morning. I need to remind you that your choice to represent yourself, you're making that on your own. Is that correct?
That's correct. Sir.
You understand the court can appoint an attorney to assist you?
Yes,
Yep. I know. Yeah, I know he's helping you,
yes.
but you understand that he's not really representing you. Like, in other words, he's not doing the cross exam, direct exam.
That is correct.
All right, and you understand that while it might seem illogical, I have to, by law, require you to follow the same rules in the courtroom. Okay, so if you need to enter a piece of evidence an exhibit into evidence, you're asking questions, you're going to have to follow the same rules. Okay, and just make sure you say yes.
Yes.
Thank you. Every person has a right constitutionally to due process, and every person also has the right to represent themselves. And again, I also just needed to make sure today that you are making this choice to continue without counsel. In other words, representing yourself on your own. Is that right?
That is correct, yes.
And the key issue when I say on your own, no one's forcing you, no one's pressuring you. It's your choice.
They are not.
Okay, copy that.
May I?
Yes, sir.
It's It's my understanding, Your Honor, that there's a conflict of variance in the law, equity should prevail. I'm prepared to wrap this up and settle all of this. It can be done here in this venue that's exclusive of Article 3. Constitution.
I know it's a bit hard to make out, but he mentioned something about a conflict between different types of laws and how he's ready to settle everything using his imaginary equity, which, according to him, exists only in his mind. He claims he can grant this equity to anyone, whenever he wants. Maybe it's a legitimate currency in his fantasy world, but in reality, it's just the currency of fools. And the worst part? It doesn't do a thing to help the mother of your child, to whom you owe real, hard-earned child support.
I appreciate that interest, but I can't. And let me explain to you why, very briefly. The law and the constitutions for both the state and the United States direct that each side, and that's important, each side has the right to a trial with a jury of 12 impartial persons. And I'm really just sitting here. I don't know anything about the case other than what I see on the charge sheet, which just tells me what there's 2 charges of failing to pay child support.
Correct.
If you all can't negotiate that between you, I don't really get involved other than monitoring the cases and making sure I know when I've got to be here and what's going to trial. I don't get involved. And even now that we have a trial by jury, I'm not involved other than I'm telling that I run Tiger Stadium here. I mean, this courtroom, and this stadium will be available for the 2 parties. That's it. Okay. So I appreciate that might be your interest and that might be an objective. I can't make a ruling unless there was an appropriate motion. Now, in a criminal case, you can't file a motion to dismiss. I'm always surprised by how many attorneys, not these 2 gentlemen, would file a motion to dismiss in a criminal case. You can't do it. You can in a civil suit. That would be different. But here, we can't do that. The law does not allow me to resolve this case unless you were all doing a trial without a jury. Since you're doing a trial with a jury, all I'm in charge of is monitoring Tiger Stadium. Okay?
Could you please repeat yourself the last 2 sentences, because I heard something in there. I want to make sure I heard it correctly.
Hopefully I got it right. You can't do a motion to dismiss. Well, you can in the middle of the trial when the prosecutor rests. If the prosecutor doesn't prove each element, then you can do a motion for a directed verdict pursuant to Michigan Court Rule 6.429. Either 429 or 419. I think it's 429. You can do a motion for a directed verdict at that time. Until we get there, I can't dismiss a charge. There's some other rules, like if he violates the 180-day speedy trial clock, right, and you're sitting in trial in jail. But other than that, there aren't any ways that I can dismiss the case unless this case is before me. There's no jury and it's in a trial. So if you requested and waived your right to a trial, by the way, Mr. Denhouten would have to waive his right to a trial, and I would have to agree. Since you both have told me you want a jury trial, or at the very least, Mr. Denhouten has, I can't decide the case. Okay, that's all.
That's
okay. It's all right. That's what I'm here for.
I do appreciate you bring up the Constitution, because the arrest warrant regarding when I was arrested in this matter was done ex parte. I had no notice of this.
Yeah, most arrest warrants are done ex parte, but they are carried out in person, though.
It's okay.
With their client.
An arrest warrant can be issued ex parte. The law allows that. There are rules that allow a district court judge or magistrate to issue an arrest warrant based upon a complaint.
Under the rules, but where does it say that in the Constitution? Because I've been reading that puppy backwards, forwards, upside down, sideways.
It doesn't. It just says it just says an arrest without a warrant is illegal. But the Michigan law doesn't. Michigan law tells us what we can do, or what, not we, but law enforcement can do, because they don't work for me. I don't work for them. They have issued a warrant.
Right.
And they did it according to the rules.
Yes.
Yes.
And Marbury versus Madison, any law that Congress or any legislature passes, if it violates the Constitution, it's null and void on its face. I'm not
That's,
here to argue, I'm just
that's okay.
making you aware
Uh,
of
it's-
what's happening.
It's been a long time since I had that class, which was common law, where we had to deal with Marbury versus Madison. I'm aware of it, but as of right now, there's nothing to address. So bond continues. We'll see you on the 19th, sir.
All right, that wraps up the first hearing. Now, let's move on to the second one, which ended up being another pre-trial conference instead of the jury trial we were all expecting.
We're on the record today, 28 on Circuit Court here in Missaukee County. Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat. I don't know which attorney's handling it. So
We are David Denhouten on behalf of the people.
court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things the law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor, yes.
And I think you've represented yourself in this file the entire time,
Yes.
and through district court. Okay. All right, so we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, I assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. Even though it looks like the information was dated February 5th, but filed on the 6th. Now, we're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are I'm going to ask a couple other questions. The first thing here is see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right. Mr. Thompson, is there any resolution between this case, in this case, as far as you know?
Your Honor, I believe there is.
Okay, well, hold on. I just got to ask the other party first. Because a resolution means an agreement. Mr. Denhouten, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that blank. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with the ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicature Act revised in 1961, Act 236, under Section 600.576, depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. I'm still trying to make sure all of this gets settled and closure in honor.
Why do they always have to say something so ridiculous at the end? I mean, when I go to the grocery store, I don't pay the cashier and then say, "Our debt is now square in honor." It just makes you sound as crazy as when you claimed you filed some certificates with the court, thinking that somehow, magically, it would make all your felonies disappear.
Oh, okay. Um,
That would be another one of those envelopes that you.
yeah, I understand. Okay,
If there's any other instructions or I
And you
feel
ref-
my duty that I'm aware of, but I'm willing to correct my mistakes.
okay. Let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay, and how do you think deposit, what did specifically, again, did you deposit?
A certificate of security.
Okay, and so what security was it that you tendered?
That was consideration
Or,
for any outstanding liabilities, Your Honor.
so your deposit of this certificate of security applies to, how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance.
Okay.
In
All right, so, and you think that somehow takes care of this particular file?
due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail. And equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right, so are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, there isn't, you don't owe anything.
My knowledge, I do not. I have,
No, so
to my
then,
knowledge, I'm free and clear of liability, Your Honor.
no, liability is a different word. Liability doesn't apply here yet. Right? There's no piece, there's no judgment that says you owe anybody money. So there's no
That's-
liability.
Thank you for
You'd better thank him now, because once the trial starts, he won't be able to help you look any less like you've got a fool for a client and an idiot for a lawyer.
Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
No. Multiplicity is something different. Multiplicity is generally used in if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay.
May-
So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the
Okay.
green card recent.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium, so we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota, that's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're gonna get 2 bites of that apple. Today's the first one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled, People versus Thompson, set for May 6th? That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhouten reach an agreement, that's between you guys. I don't care what you guys deal with right outside. Has nothing to do with me. Mr. Denhouten says they don't have an agreement, which means your offer has been, at least at this point in time, rejected.
How could the prosecutor possibly reject the offer? He filed certificates with the court and only used the bright and tasty crayons after all.
So now the next question here is, so that means we don't have a resolution today. I don't know, I don't understand necessarily the theory of Mr. Thompson resting on the statute that he referred to. This has nothing to do with liability, because so far it doesn't end the case. You can't pay off a fine until I order a fine. So therefore, the next question I have is, and I know that Mr. Thompson is currently on bond, so we don't have any issues there right now yet. I know there's a bond petition. The next question here is, have you gotten all the evidence, the discovery in the case, like the police report, any
I'm not
body?
sure.
Yeah,
Sorry
it's
to
okay.
interrupt
It's
you.
okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, should be a lab report from the Department of State Police, the Forensic Crime Lab?
I'm not sure if I've got that yet.
Mr. Denham, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, I believe it has been submitted, but I don't believe we have a copy of it.
All right, so that means I turn over here, and I'm just gonna say on my discovery issue, still,
Your Honor, I stand corrected. I do have a copy.
never mind, I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay, let's make sure that I ordered the prelim transcript.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right, so I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those, you say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. Let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggie, that will be put into evidence. That'll be listed on there. You'll get the baggie. You'll get the test of that baggie. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever to have a substance retested, it can ask for that, but it pays for it you would pay for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey, police agency, send it to that lab.
Oh, Judge, there's no need to go through all that. I'm sure the defendant would gladly offer his services to test the substances himself, and all for free.
So, things like that. So you can ask questions about discovery. But so far right now, it seems like you have it. But again, if you look at that police report, look at the last 2 pages, it will list all the exhibits, and you're going to want to make sure you've got those exhibits. And typically there's some kind of body camera. Now, by the way, unlike what they show on television, not every body camera works all the time. Not every body camera gets digitally downloaded for some reason. I don't know why, but you just can find out that information. And sometimes, by the way, they're muffled. Good luck figuring that out. All right. So we don't have a resolution. We don't have any discovery issues. The next question is do we have any motions? Now, Mr. Thompson, inside my schedule order, I said, if you have any motions, such as a motion to suppress, you can raise it within 30 days of the transcript. So if the transcript gets provided to you, and let's just say for a random choice, March 15th, you have until April 15th to raise a motion, like a motion to suppress. Okay, now that I've covered all that, now let's turn to this last question here. The next question here is, Mr. Thompson, looks like on February 19th, the prosecutor filed a petition asking to show cause. Now, basically alleging that there was some kind of bond violation. Particularly in this instance, the bond violation is that you allegedly failed to appear for a drug test on February 9th of 2025, and then February 16th, 2025. Now, the prosecutor could have asked for a bench warrant. He didn't do so, which is pretty common in this kind of a situation. I can tell you that either party or the court can ask to review someone's bond. And there isn't a right to a trial. There is no jury. There's no proof beyond a reasonable doubt. It's just that the court looks at it and gets to determine whether or not that's a violation. And then, if so, what should I do? Should I revoke bond? Should I remand the defendant into custody? Should I modify the bond? Or should I just wag my finger and say, don't do that again? Now, do we want to have a hearing on that? Do you want to have a hearing? And by the way, well, hold on. Miss Dean Stark joins us today, also via Zoom from the Wexford Misaki Community Corrections Program. Miss Stark, are you here for this one?
Yes,
I just want to ask you this question. Have there been any other alleged violations?
two violations on the 9th and the 16th for no shows.
All right, but nothing since then?
No.
All right, thank you. All right. Has he shown up at all for any testing?
He has.
All right, any, I assume they've all been negative?
Just positive for THC.
All right, and that probably wasn't listed. Okay, all right. And by the way, Mr. Thompson, if you admit to failing to show up for those two tests, I'm just going to go with the finger wag. And say, don't do that again. Make sure you show up. Okay. Is it true you failed to appear for those two tests?
By mistake, I did, Your Honor.
Okay.
I apologize on behalf of the court.
As long as you've been going to testing and you've been, and it just was on a couple different events. I will note they appear to both be on a Sunday. So I'm just going to say, make sure you don't. The court finds that there's been a bond violation, but the court is not going to revoke, modify the bond. I'm just going to do the finger wag. There we go. All right. Yes, sir. Anything else?
I wish to express gratitude, and I appreciate the court in its leniency. And I also want to let the court know that every day of my life is getting better.
I'm glad to hear that, Mr. Thompson.
I appreciate the opportunity.
Yeah.
I'm actually glad to hear that too. Now, just imagine how much better your life could be if you dropped the whole Domestic Terrorist Act, stopped trying to pay your debts with made-up certificates, and actually paid your child support instead of your local drug dealer. That wraps up today's video. I'm keeping a close eye on this case, so if there's any update, I'll be sure to let you know. If you liked the video, hit the like button. If not, hit the dislike. But don't forget to drop a comment below and subscribe with notifications on so you never miss any of my content.